Thank you very much for joining us this afternoon for our session on ideas with respect to determining disputes at an early stage. We're delighted that so many of you have joined us online this session, and it's also a delight to see some familiar faces in the audience. We look forward to having a drink and canapes with you afterwards. We are honoured today to be joined by Lord Carnwath remotely. Lord Carnwath, having retired from the Supreme Court and the Privy Council in March 2020, is now an associate member of Chambers and obviously has a particular emphasis on arbitration and expert determinations and other forms of alternative dispute resolution. So we are particularly honoured that we are going to hear some of his wisdom and experience in relation to the sorts of topics that we're going to explore on early dispute resolution this afternoon. May I also introduce you to the other two speakers this afternoon, both of whom have recently joined Chambers. Andy Creer, who was called to the bar in 2005, has joined us from Gatehouse Chambers in London, and Kate Traynor, who was called in 2019 and started her career at Exchange Chambers, has also joined us. So we are particularly delighted to welcome to the property group at Landmark, and also I think it's for their first seminar for Landmark this afternoon. So thank you. Turning to the selection of topics that we're going to cover this afternoon, I'm going to kick off with the early neutral evaluation procedure, and then Lord Carnwath is going to give some general thoughts on that after I've set out some of the basic principles regarding that topic. We're then going to hear from Andy with regard to expert determination and how that can be utilised at the early stages of dispute. And then we're going to hear from Kate on some more familiar early dispute resolution procedures regarding expedition, split trials and preliminary issues. And then we're going to turn to a much neglected topic these days, which I'm going to finish on, which are applications under Section 49 of the Law of Property Act, which were traditionally known as vendor and purchase summonses. And don't worry if you don't know a thing at all about those, because it isn't even in the index to the right book these days. It's a statutory provision. So we'll return to that one at the end. I need to deal with some housekeeping points at the beginning. Your microphones are automatically muted, so you won't need to adjust your local settings. So far as questions are concerned, we are very much encouraging those this afternoon. Can you submit them via text in the question and answer section at the top or bottom of the screen, and can you press send anonymously if you don't want your name on them? And we'll hopefully be able to answer as many questions later on as we can do so. The webinar will be recorded. You'll get a link after the presentation, the recording, shortly after we've concluded. And if you lose the connection at any stage this afternoon, please, we invite you to rejoin by just clicking the original link. So on the basis of those housekeeping matters, I'm going to start by talking about early neutral evaluation and address some of the very basic core principles with regard to this. What is early neutral evaluation? Well, it's a form of dispute resolution which involves an independent person with a particular relevant expertise expressing some opinion about a dispute or an element of it. The opinion doesn't need to bind either party, and it may be without prejudice, but hopefully it can assist in the settlement of a dispute or just part of a dispute. What are the potential benefits of early neutral evaluation as a form of dispute resolution? Well, I would venture to suggest that in property litigation cases, it can be of particular value. Why do I say that? I say it because very often in our sorts of cases, you can have a particular discrete issue upon which there may be two or a range of respectable opinions to be held on the topic. The clients may want certainty as soon as possible. They may want the dispute dealt with as effectively as possible. The case may not be suitable for a summary disposal, and there may be no other shortcuts available in terms of getting the case to trial. or indeed certainly no shortcuts on an appeal procedure that may ensue. But additionally, and this is perhaps one of the reasons why we're having this particular topic discussion this afternoon, Chancery these days has a few further hurdles that we all have to go through before our case goes to trial. We've settled into cost budgeting now, but having got used to the administrative burden of that, we then had to deal with the disclosure processes which have been introduced, which can be very expensive, very administratively onerous for a client, and consequently are very, very expensive. Having then also just learned to deal with that, we now have the dreaded witness statement, Practice Direction 57AC, which may take some of the time away from the solicitors in relation to witness statements, but puts a lot of time onto clients because they are so very much left to themselves now under the direction of the solicitors. And that can be a very wearisome and onerous burden in practical terms for clients. So we seem to be having additional obstacles put in our way, if I might suggest, before we get to trial, for which it wouldn't be surprising from a client who, having gone through that, would say, I wish I'd been able to sort this out much more quickly, right at the outset. Now, obviously, we've always had without prejudice negotiations, we've got mediation, but sometimes they don't really cut the mustard for this sort of dispute. Particular clients want an assessment on the merits of an early stage. They want someone to say, well, I'll settle this, but I think I'm right. I want someone to tell me if I'm right. They may also want to hear someone in either some form of judicial capacity actually tell the other side about their lack of merit. So it may not be simply that they want their decision based on an assessment of merit, but they may also want to be encouraging and indeed obliging their opposite party to have to hear about their lack of merit, not simply from a mediator, but from somebody who's actually going to say, this is my assessment at an early stage. And early neutral evaluation provides the opportunity of doing that, potentially without too much delay and without too much expense. So I've touched already upon a distinction with mediation, i.e. that in mediation, the mediator is principally a facilitator who's they're not making an assessment on the actual decision necessarily. Of course, mediators frequently do the reality check, the reality testing conversationally with the parties on a mediation. But there are mediators I know who don't do that approach at all, who don't like to do that approach. And so when the mediator is very much a facilitator, it's not necessarily the case that they either give or that the client expects to receive a specific assessment on the merits. I then turn, if I may, to the features of early neutral evaluation, which are it being non-binding and without prejudice, so that the parties are not restricted by reference to that decision, but they can be. And that's sometimes overlooked, I think, in relation to early neutral evaluation, because you can use that to your advantage in certain circumstances. It can provide a method by which you can have an assessment which parties agree to be binding on a temporary basis until the final decision in litigation is arrived at. Or, perhaps even further than that, they might decide that what they want to do is to have a situation where they have the early neutral evaluation, and if after a certain period of time one party doesn't dispute it, that it then becomes binding. So it gives that flexibility as well. Once the assessment is out, the parties have their freedom of choice as to how to allow the early neutral evaluation to affect their position. So practically speaking, how does one arrange an early neutral evaluation? Well, one can arrange that privately. By what I mean there is that there can be an appointment of a QC or a retired judge. There can be a specific appointment agreed upon between the parties in a similar way to that for mediators and arbitrators sometimes. But they're also the court processors. And I just want to say a little bit about that now, because early neutral evaluation is, as some of you may know, offered by the Chancery Division. And that is a facility offered with respect to all levels of judges, whether that be a Chancery Master, or it can be a Section 9 judge, or it can be a High Court judge. And the procedure in relation to that court facility, it's set out in the guidance in Chapter 18 of the Chancery Guide, which also very helpfully provides a specimen draft order to deal with such matters as the lodging of sometimes it's called the position statement, sometimes it's called the claim document, the lodging of the papers, and setting a date for when the judge will consider the matter and date by which he will actually arrive at the decision, and a direction that it can be non-binding and informal and confidential to the parties. But again, that doesn't have to be there if the parties don't want that. If it is confidential and non-binding, then the court won't retain on the court file any of the papers lodged, any record of the judgment, and obviously the assessment will, the person involved in the evaluation won't be involved at any further stage in the litigation if it proceeds. Incidentally, there is a process which has the abbreviations at CHFDR, which is a Chancery Financial Dispute Resolution. Financial dispute resolution is a procedure which has become very familiar in its inception in the Family Division, and is also making its way more in the Chancery Division now. One of the features about that, which we're not going to talk about in any depth today, but I just mentioned, is that in that scenario, the judge may facilitate negotiation and provide an assessment. So you have the best of both worlds, potentially, in terms of mediation and early neutral evaluation. So far as the Queen's Bench Division is concerned, the guidance in relation to the procedure there is set out in a case called Telecom Centre UK Limited and Thomas Sanderson, in which Master MacLeod gave guidance on the approach to be taken there, and there's a draft, a template order which can be utilised in that division. Finally, in terms of the basic principles on this, I want to talk a little bit about Rule 3.12M of the Civil Procedure Rules. And this rule sets out that, except where the rules provide otherwise, the court may take any other step or make any other order for the purposes of managing the case and furthering the overriding objective, including hearing an early neutral evaluation with the aim of helping the parties settle the case. So there, right at the outset of the powers and civil procedure rules that a court can deploy in relation to litigation, is the provision whereby the court can itself order an early neutral evaluation. Now, for a long time, and in the guidance on the topic, the view was always assumed to be that that nevertheless required the consent of the parties. But we now know, since case in 2019 called Lomax and Lomax, from the Court of Appeal, that they made a ruling that the court can order an early neutral evaluation, whether or not the parties give consent. So that's a very, very important development in the future, because here you have a court saying, I'm going to direct an early neutral evaluation, so you can hear about the merits of your case, whether you like it or not. And it will be very interesting to see how the exercise of that power evolves. What Lord Justice Moylan said about why that was the right scenario for court was this. He said in paragraph 31, it required parties to focus on whether a case might be capable of settlement and requires them to hear a judge's neutral evaluation. It requires them to hear this because the parties can be, and typically be, ordered to attend the hearing permitted by Rule 3.12, because one of the key purposes of such a hearing is for the parties to hear directly the judge's evaluation of the case. Also, and then it goes on to say, based on my experience of financial dispute resolutions, the result of requiring parties to have such a hearing can and often will be to achieve a great deal, including saving rather than adding to costs. In conclusion, I see no reason to apply into subparagraph M any limitation on the court's power to order an early neutral evaluation hearing, the effect that the agreement or consent of the parties is required. Indeed, in my view, such an interpretation would be inconsistent with elements of the overriding objective, in particular, saving of expense and allotting to cases an appropriate share of the court's resources, and would therefore be contrary to Rule 112B, i.e. the overriding objective. So here, the court is making it clear that it will put the whole force of the court's order behind potential early neutral evaluation. And it will do so because the court considers the overriding objective is achieved by parties having to hear an assessment of their case, whether they like it or not. Now, I'm going to pause there and invite Lord Carnwath to come in at this stage with some of his observations about where early neutral evaluation could take us.
Hello, thank you very much, Catherine. I'm very privileged to be allowed to join in this seminar with Landmark. I'm doing so more as an observer than as offering any particular enlightenment. It's a very long time since I was in the position of advising clients on how to move forward in their disputes. But having been a judge at all levels, from the Chancery Division up to the Supreme Court over 26 years, I have had quite a lot of experience of seeing how long drawn out and costly adversarial legal proceedings can be, and also, unfortunately, how uncertain in their outcome. Since I retired 2 years ago and was welcomed back to my old chambers Landmark, I've been keen to explore the different ways in which one can cut through these costly proceedings and try and encourage the parties to reach an early settlement, which is in the interest of everyone. I think we've heard about the early dispute resolution approach. I think it's interesting. I mean, looking back on my experience as a judge in the Chancery Division, the cases we had could sort of divide between those cases which really turned on a clash of personalities. Interesting how once they got into the box, one suddenly realized why there were these clashes. But I mean, mediation can sometimes help to resolve that. But in other cases, and quite a lot of cases, at the heart of the dispute is a sort of issue either of law or fact or even expert opinion. And if one can clarify that at an early stage, then it may help to clear the air and give the parties assistance in resolving the rest of the dispute and coming up with a sensible solution. I was very interested to hear how, since my day, the sort of procedural rules have moved on and how the judges have used that to encourage and sometimes even direct early neutral dispute resolution. And that is obviously an interesting way forward, and very interesting to see how that develops. I was interested to see actually what a question we already had from someone who's saying, well, what's happening in the tribunals? Of course, the Lands Tribunal, the upper tribunal, I was very closely involved with the setting up of that. And we are certainly very keen to encourage ways of alternative dispute resolution in that. But I don't have any direct experience myself of how that's worked out in practice. But there's certainly no reason why these procedures should not operate equally well there. So I think we're hearing today about different ways of doing it. I mean, the one we've heard about, it doesn't result in a binding determination, but it certainly may clear the air. And I think, if I may say so, as a sort of judge, one has a slightly different way of looking at these cases because one comes very much from an independent point of view, which can be quite assisting to the parties. But then we'll hear about expert determinations and other preliminary procedures. I think these are all really worth exploring, and I hope that with the other members of the landmark property team, I'll be able to do that over the coming months. I think now from the people who are listening, I mean, I don't know how many of you are solicitors, or probably most of you are, or have clients. You may think, well, we're not going to win the fees of the prolonged litigation, or too bad. I think you'll end up at least with much more contented clients, and that's probably the best objective. So on that note, I think I'll hand back to Katharine to introduce the next speaker. Thank you very much.
Thank you very much, Lord Carnwath. So I'm now going to hand over to Andy, and then hopefully we'll be able to bring some more of the topics that Lord Carnwath and I touched on in conjunction with those other issues all together in relation to some of the questions and observations. Thank you.
Thank you. Good afternoon. So as Katharine has kindly said, I'm going to be talking to you about expert determinations. It's another way of getting a quick decision, but this is one that's going to be binding on the parties. It's a form of delegation to a decision maker who is chosen by the parties. Ordinarily, it's a paper-based procedure, but it represents a quick and a relatively inexpensive way to get an informed judgment. As it is less adversarial, it can be a useful tool when the parties are going to have a continuing relationship. It's right to say that it doesn't work for all types of disputes. For those, for example, where you're going to have extensive factual evidence or issues of credibility, but it is very good where the parties need a technical or scientific approach to be taken by their decision maker. It's a procedure that's evolved from valuation cases, so it lends itself very readily in a property context to rent review cases and to Part 8 lease renewals, but equally it has a place in matters like delapse, boundary disputes and service charge disputes. And as I've said, it is going to be contractually binding between the parties unless, in a rare instance, it is set aside. And actually, it was only when I was thinking about this talk that I realised that as property practitioners, we are already familiar with a statutory form of expert determination in the Party Wall Act, etc. 1996. So the referral to a third surveyor there is in effect a form of expert determination, albeit one that's on a statutory footing. Just going to let you read this slide for 2 seconds. So the point is here really is that an expert determination is not perfect. The expert is not bound to follow all the rules of natural justice, but they do have an implied obligation of fairness, and what they lose in perhaps that rough and readiness, they gain in their ability to contribute to the control of the process. Just going to highlight some of the key differences with arbitration, because arbitration is probably a more familiar format for most people. So in expert determination, the parties have absolute contractual freedom over the process. They can set the parameters, and that can include the extent to which the expert can lay down the procedure, or the parties can stipulate a procedure to be followed in terms of evidence, in terms of submissions and responses, and so on. Unlike Section 9 of the Arbitration Act 1996, There's no automatic stay of proceedings if there's a binding arbitration agreement provided for in the lease or contract. And the parties will have to rely on the court's inherent jurisdiction to stay proceedings if there's an expert determination clause in the lease. An important factor is that the expert can adopt their own inquisitorial approach. They can undertake and rely on their own research, and they can disregard the parties' submissions and apply their own knowledge and skills to that determination. So that's a real distinction from both litigation and arbitration. There's no cost to jurisdiction. The parties have to give the expert the power to award them, and if they wish the expert to do so, potentially they have to give them any factors or presumptions that need to be applied in making that decision. And then finally, as I've said, the decision is only enforceable as a contract. This means that we have to bring a claim for specific performance or for breach of contract. And unlike an arbitral award, it can't be enforced as a judgment or potentially as a judgment in international jurisdictions. I'd like to highlight some practical considerations in respect of expert determinations. Two really spring to mind. The first is the extent to which pre-action disclosure might be available in an expert determination, because by contrast with arbitration, we know that it's not available, and we get that from the case of Travellers Insurance Company Limited and Countrywide Surveyors. And in that case, Mr. Justice Coulson held that the High Court had no jurisdiction to order pre-action disclosure. And ostensibly that was because Section 44 of the 96 Act gave the High Court specific remit in specific instances, and pre-action disclosure wasn't one of those. Now, although there's no equivalent statutory overlay for expert determinations, it's likely that the court will take a similar approach, albeit for different reasons. But the reason will be, in my view, that Rule 31.16(3) requires the court to consider whether the applicant and the respondent are likely to be a party to proceedings. And clearly that's not going to be the case if the parties are intending that there will be an expert determination. And then the second important point is, can an expert decide a point of law? And the answer is yes, but. Yes, it's a question of construction of the letter of appointment. So where, for example, the instructions provide that the decision will be final and binding without recourse to the court, then it's likely to be inferred that the parties intended the expert to decide any points of law which arise within the scope of that remit. And of course, in some cases, a decision on a point of law is going to be intrinsic to the referral. So if we take, for example, a boundaries dispute, the expert is going to need to be able to interpret certain legal documents and to consider certain legal arguments. However, the parties can, and often do, make provision that there will be a referral either to the court or to a legal expert on a point of law. And if they're going to do that, the case of Mercury Communications Limited tells us that they need to do it before the expert's appointed. If the expert makes an error on a point of law, which has not been delegated to them, then the determination can be set aside. I'm going to touch on some tips for drafting, and I've split these into two. Firstly, the referral or the clause in the lease which provides for the expert determination. Clearly, we need to precisely define the issue or issues that the expert is going to deal with, and then drill down into that issue to make sure that the expert is likely to have the right qualifications and expertise. It's helpful to have a default procedure if the parties cannot agree the appointment. Because if they can't agree the appointment, the process stalls and the court has no ability to substitute its own mechanism. And it's useful also to check whether any professional body who may be provided to nominate the expert in default, whether they will negotiate the expert's terms of appointment or whether that is something between the parties and the expert solely. And then the last consideration here is it's useful to have an express obligation for the duke party to either act in good faith or to cooperate in the appointment. The case of Creer Holdings Limited says that there is an implied obligation and that the parties cannot unreasonably withhold consent to the appointment, but nonetheless it's useful to have that express provision in the terms of engagement. And then secondly, what are we going to do in terms of the letter of instruction? The letter is key, because if there's a dispute about the expert's scope, then it is this letter and not any earlier correspondence which will define the expert's mandate. We need to consider whether the procedural framework needs to be defined, or whether the expert will in fact be given the scope to set their own timetable and make their own decisions as to how the determination will progress. We need to make specific provision if the expert is going to have the power to order disclosure of any form, or indeed if they're having an oral hearing, to witness summons a person to give evidence. The expert's under no obligation to give a reasoned decision. It's only if the parties stipulate that in the letter of engagement, they're quite entitled to just give a short form answer. But if they're instructed to give a reasoned decision, the court can require them to give further reasons or additional reasons, because it's a matter of enforcement of that contractual obligation. And finally, we need to specifically make provision for if we want the expert to award costs or to award interest. It's also useful for the parties to have a provision that the expert can proceed with the determination if one or other of the parties do not participate or comply with the directions themselves. It means, again, that the process doesn't stall. One of the key positives of an expert determination is that it's unusual for there to be an appeal, which in litigation or arbitration will add this further layer of cost and delay to the decision. Now, there are limited grounds on which an expert determination can be set aside. If the expert's materially departed from the scope of their instructions, if there's a manifest error or the decision is vitiated by fraud, or if there's partiality. And I'll just explain each of those to you briefly. So firstly, not acting within the scope of the instruction. If the expert misinterprets the agreement and makes the determination on the basis of an incorrect interpretation, then he or she has not done what they were asked to do, and the determination is invalid. But if he or she interprets the words correctly, and then the application of them is wrong, it's only going to be in circumstances of manifest error that you are likely to be able to set it aside. So it's common to see the parties have a specific term in their agreements, but it's only going to be when manifest error or fraud will allow the parties to set it aside. And we get the definition of manifest error from Weber Oil, which is oversights and blunders so obvious and obviously capable of affecting the determination as to admit of no difference of opinion. But absent such a term, the expert determination will not be invalidated if the expert makes an error. And then the third ground of procedural unfairness or partiality, and I'm grateful to one of my solicitors who tipped me off that this had been her case, and I hadn't been aware of it until she did, so thank you. This was a share sale agreement, and the expert communicated to the parties that she had made her decision and it was ready for release pending receipt of her fees. She then received further information from one of the parties, and it was key information because it went to the price of a property, or the guide price for a property that was being put up for sale, which was the company's main asset. And she took that information on board, where her instructions had been that she needed to get a professional valuation for the property. And she took that information on board without giving the other party an opportunity to comment on the evidence. So unsurprisingly, the case was held to be invalid, her determination was held to be invalid for two reasons. Firstly, as a matter of construction, she had not acted within the scope of her instructions, but also by not inviting submissions from the other party, her decision was procedurally unfair. But Griffin does tell us that simply telling the parties that I'm ready with my decision does not end the expert's mandate. At that point, she would still have been at liberty to change it. It's only once it's been issued that the role finishes. So in summary, as property litigators, what do we see as the advantages of an expert determination? Well, I think the main one is that you choose the expert. I'm fairly sure that we'd all be quite happy sometimes to be able to choose our judges, but unfortunately we don't get that luxury. It can give you a quick decision, and it's relatively inexpensive. So when I've acted as an expert, the parties have had a decision from drafting the instruction through to the decision in 3 months, which I think, compared with 18 months of arbitration or litigation, can be a quite attractive option. And as well as finality, the process is confidential. So it's not something that you need to disclose any commercially sensitive information in the public domain. So thank you. We're going to take questions at the end, and I think I'm handing back now to Katharine.
The court's power to order a preliminary issues hearing is derived from CPR 3.12. There isn't a specific definition as to what a preliminary issue is, but it's generally considered to be a point that could be decisive or potentially decisive and capable of determining or deciding the significant element of the claim, potentially reducing costs or minimising the scope of the main trial, and hopefully improving some form of settlement for the whole proceedings. The court can generally, amongst other things, direct that there be a specific trial of a certain issue, decide what issues should be considered, and give a judgment on that particular issue, which would be binding upon the parties. The main guidance is set out in Steel and Steel, which does outline quite a useful 10-point list and factors to be considered. And the key ones that I've taken from that is considering whether or not there's a cost benefit for the hearing of a preliminary issue or those issues, whether or not it would dispose of the case or at least one aspect of that case, or whether or not the hearing of the preliminary issue or issues could actually lead to one party trying to avoid the consequences of that and actually amend their pleadings, which could result in greater costs. And it is a fact that the court will take into consideration when making their determination. Other helpful guidance can be extracted from the case of McLaughlin and from Walter and Lilly. And what these cases tell us is that preliminary issues should generally be points of law determined against an agreed schedule of facts between the parties. the schedule of facts should be articulated with some degree of precision so that the court can properly understand the case presented before them, and that the preliminary issues should be dealt with promptly and with consideration given in the context of a trial timetable for any appeal or consequential applications from that decision. There's quite a bit of court guidance on these issues, and they're a useful resource to go to and consider when assessing whether or not to actually make an application. And the courts do tend to differ in their approach. So attention should be given to the approach of the court, because you will be asked to do specific things. For example, in the commercial and circuit court, you have to produce an agreed list of key issues. It needs to be a neutral document, balanced between the issues between the two parties. And this generally has to be done before a CMC. And there also needs to be a case management information sheet given in advance of the CMC, outlining a person's position on whether or not there are any preliminary issues. And as I say, this differs from court to court, so it is useful to refer back to that guidance before proceeding with any form of application. Other authorities which are helpful in setting out whether or not a preliminary issue should be progressed and whether it will assist in terms of saving on resources, costs and time are those which I've highlighted here. But in particular, one authority I found quite useful was actually that of Takeda Pharmaceutical, and the parties had originally in this case considered making an application for an expedited trial as the matter concerned a time-sensitive case involving funds held in an escrow account that needed to be released. And as opposed to forming and sending through for an expedited trial, the court considered and formed a view that a determination on preliminary issues would actually dispose of the case in a much more cost-effective and resource-saving capacity, and therefore proceeded down the route of preliminary issues as opposed to expediting the trial. In terms of cases of property contacts, where I've seen there to be a preliminary issue is where there's been an issue for the validity of a notice. So, for example, in a possession claim, if the parties are asserting it's a defective notice, the court will sometimes hear that as a preliminary issue. Other contexts are on a ground F of application where there's an opposed lease renewal. The court will tend to consider preliminary issues in those contexts. Or another example is when you're concerning the construction of a landlord's repair obligation and corresponding access before establishing breach of liability or trespass in a claim. With regards to split trials, from my research and from dealing with these, I found that some courts didn't actually differentiate between a split trial and a preliminary issue, and they use the language interchangeably. And some decisions where there's been reference to a split trial, it's actually a preliminary issue. And the only guidance that I found that specifically differentiates between them is in the TCC guide, and that does suggest that it's sensible when there's a division of quantum and liability for there to be a split trial in those circumstances. In terms of procedure, again, the court's power is derived from CPR 3.12, and any party can make an application in the usual manner. One thing that is worth noting procedurally is that when you are making an application, the court does require that the draft order properly formulate and identify the issues and precisely define them. The reason for this is that in order for it to proceed as a split trial, there needs to be quite a decisive line on the issues. If there isn't, the court will find it overcomplicates matters and will protract problems or won't actually facilitate a split trial. There's a non-exhaustive list set out in the case of electrical waste recycling group. These factors were considered in the context of a personal injury and clinical negligence claim, but they have been applied in subsequent cases, such as a case of Daimler, where this concerned the application for a split trial in relation to a cartel competition claim and whether it was appropriate there. And both cases provide useful guidance to when the court should order a split trial and what considerations should be taken into consideration. For example, defining the split. This is an important factor. The court will, if there are any difficulties in doing that, the court won't consider it appropriate because there needs to be a very clean split between the issues. If there isn't, then the court will consider that the application likely to fail. And if you do make an application in such circumstances, the courts have been known to order wasted costs. Another important factor is the timing of the application. An application should generally be made promptly after the point of issue and preferably before there's been any case management decisions. There's a case of Clutterburg, which concerned a multi-million-pound claim for damages arising out of a property joint venture agreement relating to prime residential estate in Belgravia. And the court said that this was a key example of when an application for a split trial is made too late, as it was made in their closing submissions, when it became apparent that their expert evidence had significant gaps. And essentially the court said that you cannot use an application for split trial this late in the stage where it will cause prejudice, but also to cure defects in your own claim. Examples of where it might be appropriate in a property context claim for a split trial is things like dilapidations, but there needs to be a clear and decisive split on liability and quantum. Other claims may be where there's property misrepresentation or solicitor and surveyor professional negligence. Generally, split trials are seen outside of property context as they suit that narrative a little bit better because there tends to be a clear split on quantum or liability. And those cases are things like defamation, probate, construction claims. They tend to facilitate a split trial more appropriately. But in a property context, in any event, a lot of the time, the judgments refer to split trials as preliminary issues in any event. Again, there's useful guidance to refer to because the courts do differ in their approaches. It is always necessary to go back to that guidance and consider what is being said before there is an application made. I think I've clicked one too far ahead. The next topic is expedited trials. Similar to with split trials and preliminary issues, again, there's court guidance which assisted understanding what the court will expect and what their approach will be. It again, cannot emphasize this enough, but it is important to go back to that because, for example, in a chancery guide, it does suggest that the applications must be made and considered in the applications court and that masters do not have the power to direct expedition. If the application is made incorrectly, the courts again impose cost sanctions. The general starting point for the court is to consider the overriding objective, and whilst they will want to bring cases on as soon as practical, they do need to consider the practicality of the timetable, and unless they are satisfied that the case meets the threshold for expedition, namely objective urgency, they won't consider that application. The leading authority and probably most cited authority is that of W.L. Gore and Associates. Here, the court in the first instance refused permission as they felt that the timetable had already been agreed 7 weeks prior, and they didn't think it was a significant change in circumstances to vary from that consent order to allow the courts to make an order for an expedited trial. However, by the time this case reached the appeal court, what was presented was a different case. The parties had been facilitated quite helpfully so by the Chancery Listing Office, who allowed this matter to be heard as a vacation hearing. and suggested that it wouldn't actually impact any other parties. So in provisionally granting a new timetable, the court exercised its discretion by reference to these key 4 factors. The first factor that the court will consider is whether or not there is in fact a good reason to expedite. What the court is looking at here is whether or not there's a real risk to one of the parties or both that there'll be some form of irreparable harm caused if the matter is not determined on an expedited basis. The court won't necessarily take into consideration the complexity of a case, and this is one issue that they will look at, but they look at it in the context of the timetable and whether or not the complexity of a case will actually be facilitated by a shortened down timetable. Examples of where the court has refused this application is that of J.W. Spear and Sons. Here it was said that there was a delay in bringing a trademark infringement case to trial, and in the event the claimant would suffer unquantifiable damages for a further 6 months of allowing this to be set out. What the applicant didn't actually suggest, and the key question they needed to consider, was the sufficient urgency as to whether or not the test met the requirements for a vacation hearing and whether the court could in fact facilitate that. Because they failed to address that question, it's one of the points that the court considered and said it wasn't met out in terms of what they needed. Another case that emphasises the importance as well of bringing a matter before the court as quickly as possible is that of Eli, Lilly and Company. Here, all of the parties suggested that they wanted to obtain some form of commercial certainty as quickly as possible. There'd been some form of delay, and what the court needed was to be set out that there would be some real or strong detriment to the parties by this delay, and that is why they needed it on as quickly as possible. As they couldn't satisfy that threshold, the court wasn't minded to expedite the trial. The desire to ensure speedy enforcement of a judgment is not considered to be a good ground which justifies expedition. What the court considers that all litigants will want swift justice, so therefore won't necessarily consider that as being a good reason. The other test of the 4 factors is the good administration of justice, and this covers having an achievable timetable for a just and proper trial to proceed, and the extent of which the parties may actually be inconvenienced by that timetable being compressed and compacted down. A point to take away from the cases is always prudent to check with the listing officer for the possibility of getting the claim heard in the proposed window. If it isn't, the court will consider the timetable not achievable and not realistic, so it's worth taking that additional step. The other point that will be considered is the unfair prejudice caused to the parties. The court generally considers that the respondent's role in these forms of applications is to set out what prejudice they will suffer by the trial timetable being compressed and expedited. But ultimately, the question still remains for the court as to whether or not to exercise and expedite the trial. What the court's also been minded to take into consideration is whether or not a particular party will be overburdened and if they have limited legal resources, so therefore placing the parties on an unequal footing. If that is the case, and it's contrary to the overriding objective, and therefore the court's less likely to allow for an expedited trial. The final factor to consider is other special factors, and this is a judicial discretion point, so it's a broad area for the court to take into consideration, but a couple of the key points is whether or not a particular applicant has acted promptly. If there's been a delay, the court will question why you've delayed, but you're now seeking to expedite a trial. Whether or not the remedy sought will actually resolve the dispute, or whether it will create more practicalities or problems, or whether in the circumstances for like an injunction, whether undertakings offered for a particular party will protect the position such that an expedited trial is not actually necessary for the parties to achieve and protect themselves. Thank you.
Thank you very much, Kate, for that. So I'm now going to talk about vendor and purchaser applications. They were formerly known as vendor and purchaser summons and were a very popular procedure historically before the land registration process. But I make no bones about the fact that today I'm going to promote Section 49 of the Law of Property Act and that we're all missing it. Because I think it's very, very useful, seriously overlooked, and I think it's a travesty that it's not in the index, the white book. Because Section 49 of the Law of Property Act is something very, very interesting, very broad. It says this: a vendor or purchaser of any interest in land or their representatives, respectively, may apply in a summary way, i.e. quickly and easily, to the court, and then it lists some specific things, such as in respect of requisitions or objections, or any claim for compensation. And here we come to it, or any other question arising out of or connected with the contract. So it's contracts for sale, it's also contracts for exchange. The court can consider in a summary way any question arising or connected. Only one exclusion in the express terms, not being a question affecting the validity or existence of the contract. I'm going to talk about that in a few minutes. But only one restriction written into the terms. And it gets even better because it then goes on to say the court may make such order upon the application as the court may appear just, and may order how and by whom all or any of the costs of an incident to the application are to be borne and paid. It's not very often these days that we get such a broad provision in terms of judicial powers on a summary hearing. There was a legislative history to it, but it was in Section 49(1), present purposes of the Law of Property Act, 1925. And in the Court of Appeal, as early as 1900, in the case of Hughes and Ashley's contract, Lord Justice Collins said that the policy of the procedure was to give suitors a cheap and easy method of obtaining a decision on points which may arise in carrying out contracts, instead of the parties being put to the expense of an action for specific performance. Don't worry too much about specific performance. Come back to that, because it's not just an alternative to specific performance. It's got a much greater potential breadth. So I keep mentioning the fact it's any question arising out of or connected with the contract. So we have no set list, but just by way of some examples, it might involve perhaps more traditionally cases about the right to recover a deposit, the sufficiency of title, the payment of duties, claims of compensation, duty to answer requisitions. But there is no limit in relation to the sorts of issues that can crop up in relation to a contract, and which potentially within the scope of this provision. Where does it cross the line then into what the express restriction is, i.e. issues affecting the validity or existence of the contract? Well, there is case law which indicates the court won't treat that as being too great a restriction. And in the Master of the Rolls said, also in 1900, in the case on it, Hughes and Ashley's contract, that essentially the court won't, and the court would regard it as very inconvenient, it said, to hold that where the parties have been acting on the basis of a contract between them, exchanging drafts, endeavouring to agree, and one party goes and takes out the vendor and purchaser procedure to settle the point. Someone comes along and says, the summons should be dismissed simply because on the parties, I'm going to raise the question whether there is a contract at all. The court says it won't have that. It won't have somebody trying to raise an argument about existence validity just to knock out the jurisdiction. In other words, it's quite strong on an avoidance policy about the jurisdiction of the Act. So to take an example of this, rescission is obviously perhaps one of the most obvious examples where you would say that was attacking the existence or validity of the contract. But if the question is actually dissected down what the dispute may be, then the court will say, I'm still going to decide it. So the obvious example, and I'm looking at Tom here, for example, given his favourite topic of notices, is if you have the issue in rescission being about the notice, the court says, of course I'm going to decide that on the vendor and purchaser application in section 49. It's a discrete issue, and I'm not going to say that's an issue which is affecting the existence or the validity, because the actual dispute between the parties is about the validity of a notice. And if the notice is valid, then the rescission is effective. So we'll take a narrow approach to the statutory restriction. I'm going to come back again to relief, but I'll say a little bit about practice and procedure first of all. How do you do this? So you do it by issuing a Part 8 claim form. In many respects, that in the current day and age makes the life easier than you might think as well, because under the new witness statements practice direction I mentioned earlier, because you are not allowed to be referring to documents and witness statements very much more, really speaking, you're probably going to be able to do a witness statement which simply lists the documents, and on that occasion, the witness statement would be allowed to exhibit the documents because it hasn't been disclosed. So you'd be in a situation where your evidence could be fairly easily put together by exhibiting the documents, and the arguments would probably be more compartmentalized into the skeleton argument. If you have something which is very urgent, it seems to me that the urgent issues, you could then actually put your application notice into the applications court, and if it's less than 2 hours, you'll get on with it in 3 days. And the court can't really argue that again, it seems to me, because there it is in the provision that the parties are entitled to have their case determined summarily. So the whole policy is for it to come on quick and easily and cheaply. I should say County Court and High Court are both appropriate forums, subject to the usual jurisdictional rules on value of claims, etc. I think the real key in relation to the usefulness of section 49 lies in the breadth of the relief which the court can order. Because I mentioned a little while earlier that Lord Justice Collins had said it was a very cheap and easy method of obtaining a decision, without parties being put to the expense of specific performance. Now, technically, on the case law, it's still a moot point whether a court can order specific performance on a vendor and purchaser application. But when you look at the case law, the courts get around that in any event, and that may be why they've never decided specifically whether you can order specific performance or not. It seems to me, as a matter of principle, that given the wording of section 49 says the court may make such order on the applications as may appear just, that it could do. But quite regardless of that, as I indicated a moment or two ago, the court seems to be getting around that very easily, and I'll give you 2 examples. There's a case called Reed David and Cavey in 1888, and to simplify the facts there, the question was whether a specific performance would be ordered against an unwilling buyer. And the reason that the buyer was unwilling was because he'd bid at auction for some premises that were described as leasehold business premises. When it came to, the discovery was that there were some very serious restrictions on the ability to use those premises for business purposes. And so the court said, I'm going to grant a declaration that the title wasn't such in this case as the buyer ought to be compelled to accept. In other words, that sale can't go through, specific performance would never be ordered. So it essentially decides the issue of specific performance in practical terms anyway. Another example, much more recently, Faruqi and English Real Estate, 1979. In that case, the contract sale had a special condition in it, which said that the property was sold subject to entries on the registered title, not a particularly unusual special condition. But there was then a general condition as well. And the general condition was to the effect that in such circumstances as that, the buyer would be entitled to copies of the relevant deeds and would be deemed to have purchased with full notice and knowledge. Transpired that there were some restricted covenants on the title, but that copies of those deeds couldn't be made available by the seller. So the issue was, again, should the buyer be compelled to actually go ahead with the acquisition? Ordinarily, you think that would be a long specific performance action. What Mr. Justice Walton said was, on the strict construction of the contract, the buyer was obliged to proceed with the purchase. But he said that this was a contract which, pursuant to the rules of equity, could never be foisted on the purchaser. It was a contract of which the court would never order specific performance, he indicated in his judgment. So he granted relief, the practical effect of which was that the deposit was returned to the purchaser, i.e. no specific performance. So you can see how, if you've got a contractual dispute, it can be very easy and very final, and the restrictions are actually very tightly construed. And when you actually look at how many cases there are some quite recent cases on Section 49. There's this little, I might suggest, it's a bit of a number that's tucked away there, which is being really neglected, and so I'm fighting its corners today. So I'm hopeful that we've got plenty of time for interesting questions on those topics. I'm going to return to the front to see what some of those questions are, which I'm hoping that Kate's going to tell me. While I read those, can I just see if there are any questions from the audience in the room, first of all? Yes, Mr. Fear.
So I've got a question about expert determination. The question is the extent to which the expert determining could be sued for getting it wrong, or as part of the instruction would seek an indemnity from the parties so they could not be sued.
So it's a very good question. There is no immunity from suit in an expert determination, and the expert will owe contractual and tortious duties and can be liable in negligence. But the expert can limit the scope of their retainer and only take and accept the appointment on the basis that they won't be sued. And if the expert acts within the scope of their instruction, it's unlikely to be you'll be unlikely to be able to find that they've been negligent, because they will have to have made a decision which is outside of the range of a reasonable decision. So it is an issue, but I don't think it stops many experts from taking the appointment.
Hi, I've got a question about early neutral evaluation, and I've never myself come across one of these. I'm curious to know whether, as a matter of what's normal, the evaluator will express the assessment as a percentage chance of winning, or is it like a draft judgment that gets read to the parties? The assessor says this is what is going to happen in my opinion, or is it a hybrid in that it's in the control of the parties to tell the assessor how they want it done?
I think that's a really good question. My understanding of the position is that there is no restriction on the form of the evaluation, and indeed that may well be within the scope of the parties' power to dictate how they want the assessment undertaken. I would have thought that in relation to the court process, I would anticipate that most judicial evaluators would adopt an approach that was perhaps a little bit more of a summarised form than their usual judgments, perhaps an interlocutory style judgment, and that they wouldn't adopt the percentage approach. But if I was a client, I think your idea is an excellent one. They give it to me straight. I want a percentage, and actually make the evaluator to take that approach. I know that Tom has some experience in relation to early neutral evaluation, and I don't know whether that was a lengthy approach or a short approach. And I'm not asking you, Tom, obviously, to break any confidentiality issue, but you may have a feel in relation to Tim's question.
So I've had one of these 2 or 3 months ago. So the other side suggested early neutral evaluation. We didn't want to be seen to be sort of running away from an assessment of the legal merits of the case. So we accepted that. We suggested a evaluation by a property QC. They wanted to go with an early neutral evaluation by a Chancery Master, and partly because it was free. So we went with that. And it wasn't brilliantly successful. Answering Tim's point, the early neutral evaluation looked very similar to what you said, Catherine, sort of condensed judgment. It wasn't expressed in percentage points. But the problem with it was just completely wrong. The conclusion was wrong. The reasoning was rubbish. And it wasn't just us that thought that. It settled at a mediation soon afterwards. The settlement indicated that both sides thought it was wrong. From what the other side said during the mediation, in fact, afterwards, we knew they thought it was wrong. So I certainly wouldn't be, if I was going to, don't know really what I think about early neutral evaluations after that, but I certainly wouldn't be running back to Chancery Masters to get one. And in fact, funnily enough, when we'd gone down this road of early neutral evaluation from a Chancery Master, a colleague in Chambers said they'd recently had an earlier neutral evaluation from a Chancery Master, but she said the problem was it was completely wrong, so it didn't help.
Sorry to butt in, but just on a related point, I have a feeling from remote sources that feedback from jurisdictions where this has been going on a long time is similar. The family division has had early neutral evaluations going on for a very long time, and it's again a very mixed bag. And I think the success of the process largely depends on the confidence both parties have in the person doing the assessment. And if what happens is you end up in front of basically a tribunal that's not been agreed on in advance, I think, as Tom's experience indicates, there's a significant risk that you're going to end up with something that goes off beam and perhaps has the effect of entrenching the parties in a mistaken view of the merits, which can sometimes be problematic and not necessarily conducive to an early or cheap settlement. So
yes, I think I would agree with those views which have been expressed, and I suppose it comes back to that point too, that if you're going to go down early neutral evaluation, you may consider whether you really want to have the opportunity of making the most of choice, which is actually to spend the money and to actually have that person who you'll get, both parties are going to have the confidence for it to have the effect that the overall objective is designed to achieve. Interestingly, we've had some feedback from the online audience in relation to this, of an experience in front of a highly respected High Court judge who didn't give a percentage chance in answer to the original question on this, but was on the basis, as I understand it, that this is what a court would like you to find, which is what I would anticipate, and I think what the process we would all hope would be intended to achieve. But that's very helpful. I'm going to turn again, however, if I may, to Andy, because Andy, you seem to be the expert determination's most popular source of questions that are coming in today. And so one of the observations which has been made about this, that the independent expert charges may be higher and often will be because of the greater risk reflecting the potential of a negligence claim. And the independent expert will undertake far more extensive investigations whereas in arbitration, such additional investigations will be more limited, far more controlled, as provided for by the 96 Act. And that in relation to charging on the basis of a percentage of claims, that can help to reflect the risk and substance of the dispute being decided. It also demonstrates the difference between the codes of arbitration charged on a time basis and the independent expert, where the key is their assessment of their own opinion of the dispute, and which is often about value alone. Which I suppose leads me to summarise the question, if I may, putting it as, which would you go for, arbitrator or expert?
I'm going to sit on the fence and say it depends on the case, but I think the speed. One of my friends at the bar said that the benefit of expert determination is that it's quick and dirty, but you're stuck with the decision. So I think if you need a quick decision, I think the expert determination can be a very useful way of doing it. The arbitration is probably more familiar territory for most people, but I am a fan of expert determination, I have to say. So why is that? I think because you're not stymied by just an adversarial process. The idea that you can have someone who is a technical expert looking at the issues and deciding them with that bank of knowledge is, I think, one of its strengths.
Thank you for that. Now, I'm conscious that I can't avoid questions for myself in this process. And one of the questions that has come in is the question of whether, with regard to property disputes being dealt with in the property tribunals, are there similar plans to introduce early neutral evaluations by an experienced property tribunal judge? I personally am not aware of such plans in relation to that, and I don't anticipate that the Chancery scheme has extended that far yet, but it may be that somebody knows differently, and if they do, I invite them to let us know. Another question which has come in is a question of whether the vendor purchaser application could be utilised in a dispute about whether an option to purchase has been terminated because the purchaser hasn't complied with the contract conditions. My answer to that question is, provided that you satisfy the criterion written into section 49, that it is a question arising out of or connected with a contract for an interest in land, then absolutely that question could be so decided. Looking at what else we've had, there's been an observation regarding expert determination being available for lease renewals under PAC before. I don't know, have you had any experience in relation to that scheme? Expert determinations on lease renewals?
I think I'm back on. Not expert determination under PACT, because obviously PACT is the arbitration on court terms, but I have seen lease renewals go to expert determination instead of arbitration, but typically not with a clause existing in the lease. It's been an ad hoc basis between the parties, but I have been involved with submissions in unopposed renewals when you get to do the issues over valuation effectively.
Now, I'm conscious without answering some questions. I've got a question actually, which, and I don't know whether anybody else, particularly again, Tim and Tom have experienced this, but I think you very helpfully emphasised that expedition is very often a matter of the practical scenario of the court at any particular time. And one of the things I've noticed is that if you have a deputy judge, vacation doesn't have the same significance, and that you may well find a fortuitous scenario where you're able to get listed in the vacation with the assistance of the senior clerk who's sitting at the back of the room there, a combination of the two things. I don't know, has anybody else had that experience that expedition can very much be based upon specific fact circumstances at any given time of the case, particularly with deputy judges and vacations. Mark, seeing it up, we used to find very much that the judging, the part of the list was all important in relation to expedition. Is your view that that's changed at all?
No, far from it. I'd say it's much the same, actually.
Would you?
Yeah, no, absolutely. We had I mean, it wasn't so much the expedition, but we had one recently. And the clerk of the list was superb and got the judge we needed. I'd say it's much the same as it's always been.
Thank you for that. Are there any further questions from anyone at all in the room or online? Carl.
Thanks. On the vendor purchase of summons, costs.
Yes.
Will it, I presume Section 49 doesn't make a provision for costs, but will it just be exercising the normal costs?
It's a really interesting question, because on my review of the case law, it not only makes a provision for the costs of the application itself, and the usual rules will be adopted in terms of the victor and the loser. But interestingly, in a lot of the cases, it's also made orders about the costs in terms of the actual contractual process. So I can't just remember the names of the cases, but I noticed this, but it actually chose to make provision for that one party should pay that the other side's costs of going through a particular process in the conveyancing scenario, which I thought was quite interesting. In other words, if you've got a dispute, the court will get hold of it and make orders in relation to the relevant events and won't shy away from that. Right, well, thank you so much, everyone, for participating this afternoon. Thank you for those who joined us online. As I indicated earlier, it's been recorded and you'll shortly get a link in relation to the presentations. And with respect to those in the room, very much look forward to having a drink with you and having some canapes with you now. Thank you very much, everybody.